Here is a structured essay that explains how the Canadian government's failure to ensure clean drinking water for First Nations communities can constitute a violation of treaty rights, and the potential legal and governmental implications if Indigenous communities pursued action based on that violation. Title: Treaty Violations and the Legal Right to Clean Water of First Nations in Canada. For decades, many First Nations communities in Canada have lived without access to clean drinking water, a reality that stands in stark contrast to the rights and protections afforded under historical treaty agreements. These treaties, which were signed between First Nations and the Crown, the Canadian government, are not merely symbolic documents, but legally binding commitments. When the government fails to provide basic necessities essential to life, such as clean water, it may be in breach of these treaties, which are constitutionally protected under Section 35 of the Constitution Act, 1982. This breach opens the door to significant legal recourse by Indigenous communities, including the potential for class action lawsuits rooted in treaty violations rather than mere negligence or public health concerns. Treaties in Canada are more than contracts. They are solemn agreements made between sovereign nations. The Supreme Court of Canada has consistently held that these agreements must be interpreted liberally and in favor of Indigenous peoples, taking into account the spirit and intent behind them rather than a narrow literal reading. R.V. Badger, 1996. In many of the numbered treaties, 1 through 11, the Crown promised to provide First Nations with the means to sustain themselves through agriculture, hunting, fishing, and other traditional practices. Access to clean water is integral to all these activities. A poisoned or inaccessible water supply not only threatens the health and well-being of these communities, but also undermines their ability to engage in treaty-protected ways of life. Moreover, the doctrine of the honor of the Crown reinforces the obligation of the Canadian government to act in good faith when fulfilling treaty promises. The Supreme Court in Manitoba Métis Federation Inc. v. Canada, Attorney General, 2013, ruled that delays and failures in upholding such promises constitute a breach of this constitutional duty. Therefore, a persistent failure to provide clean drinking water can be argued as a violation of this honor, particularly when the government has the capacity and resources to resolve the issue, but chooses not to act with the urgency required. Should First Nations pursue legal action on these grounds, the impact on the Canadian government would be substantial. First, such a lawsuit could be framed as a constitutional challenge, making it more difficult for the government to defend itself using procedural or jurisdictional technicalities. If successful, it would likely lead to not only financial compensation, but also legally mandated infrastructure changes and long-term policy shifts to ensure compliance with treaty obligations. The legal precedent could pave the way for further treaty-based challenges across other areas where government neglect has resulted in rights violations. Furthermore, any ruling that confirms a treaty violation in the context of clean drinking water would carry significant moral and political consequences. It would reaffirm the constitutional strength of Indigenous treaty rights and place pressure on the government to approach treaty fulfillment not as a discretionary act of reconciliation, but as a legal and constitutional imperative. In summary, the chronic water crisis affecting First Nations communities is not only a public health emergency, but potentially a violation of constitutionally protected treaty rights. If challenged through the courts on this basis, the Canadian government could face profound legal, political, and financial consequences, ones that could force a deeper reckoning with its responsibilities under the treaties it signed.